Hello, good morning. We are Beatriz Otero, Margarita Santamaranda, Isabel García Alegre, and me, Catalina Fernandez, and today we are going to be talking about the Special Court for Sierra Leone. So, firstly, Isabel will be presenting the background, then we will move forward to Margarita, who will be talking about the criminal facts. Then Beatriz and I will be presenting the procedure and the legacy. And finally, Margarita and Beatriz will be presenting the two case studies we have found.
So to start with, I'm going to do an introduction of Sierra Leone, and it basically what we could highlight more was the Civil War and the establishment of the Special Court. The Civil War was between 1999 and 2002, and it was the most brutal and overlooked wars in recent memory. There were many people internally displaced, refugees. Many people survived the amputation of one or two limbs. There were also many citizens and children killed, raped, mutilated, or conscripted as soldiers. Later on, a peace agreement was signed between the Rebel United Front, the RUF, and the government of Sierra Leone, and this agreement included a complete amnesty for everyone participating in the war and called for the creation of a Truth and Reconciliation Commission. Then on January 16 of 2002, the UN signed an agreement with the government of Sierra Leone to create a special court of Sierra Leone, which will be similar to the International Criminal Court tribunals of Rwanda and Yugoslavia, and it was supported by the government as well as by international human rights group, the United Nations Security Council, the United States, and the European Union. So now talking about the Special Court of Sierra Leone, basically it has helped the country to reach some closure about the war and bring justice to some of the defendants for said horrific crimes. Also envisions a new model of international justice. It was the first international criminal court to sit in the country where the war crimes took place, meaning that national and international judges sat alongside. Moreover, the agreement itself was very innovative because it's an agreement between the UN and Sierra Leone rather than the agreement by the Security Council imposed upon Sierra Leone. Those changes were very relevant to citizens, more relevant than even the ECTR and ECTY. And also presents an opportunity for Sierra Leone to punish the worst human criminal acts from the Civil War, and also another opportunity for the UN to prove that the ad hoc tribunal model can be expanded and improved upon. At the same time, even though the Special Court has provided many advantages, it also lacks many resources of the ECTR and ECTY, such as the financial and institutional support necessary in order to achieve its goals. Furthermore, there are many serious constraints that could destroy said court. The UN and the government of Sierra Leone must recognize that serious problems of the statute, which deals with, for example, funding provisions for the tribunal, trying children, lack of third-party extradition procedures, and conflicts between SCSL and TCR, among others. So if they wish to create an effective model for international justice, solutions to these problems must be found. Now, talking about the background in general of Sierra Leone, yes, the next slide. Sierra Leone became independent from the UK in 1961. Despite diamonds and other natural resources, as well as excellent farmland, approximately 70% of the government's budget comes from international assistance programs. Sierra Leone ranks also last on the United Nations Development Programme's Human Development Index, with a life expectancy of only 34 years recorded in 1999. And since their independence, politics in Sierra Leone have been rife with corruption and mismanagement. Now, in order to know more about the country, I think it's worth mentioning to highlight the Civil War, its antecedents, and how the Sierra Leone Tribunal was created. So basically, there was a civil war, which I mentioned previously, and there was a huge group, a rebel group called the Rebel United Front, which, with the support of Libya and Liberia, in March of 1991 entered Sierra Leone from Liberia, and government of Sierra Leone troops loyal to the former president there, who was called Momo, fought those troops on the Liberian border. So basically the war started until in 1999 there was a stalemate. There were previous agreements between many of both sides, but there was a stalemate between the Economic Community of West African States Monitoring Group, called the EMOGOB, which were peacekeepers who wanted to protect the capital and its citizens, and the RUF, who were that rebel group who were causing those attacks. So there was a fight, and in order to establish peace, there was a peace agreement for both sides, who was signed in July of 1999 in Lomé, Togo, who was called the Lomé Peace Accord. Bea, this slide. This peace accord was signed by the two leaders of the Rebel United Front and the government of Sierra Leone. Said peace agreement provided generous provisions for the RUF, which stated that both sides would share power and would grant a complete pardon for both the leader and all combatants in the war. Furthermore, it also called for new elections and for a review of the constitution, and in accordance, it was also established two bodies, the Human Rights Commission and the Truth and Reconciliation Commission. At the last minute, one UN representative added a reservation that literally stated that for the UN, the amnesty cannot cover international crimes of genocide, crimes against humanity, war crimes, and other serious violations of international humanitarian law. So what happened? There was a conflict between this after this agreement, because the international response to this accord was very mixed. The human rights group criticized this agreement for giving impunity to war criminals. On the other hand, the US and the UK supported this agreement. What happened? That because it continued hostilities and wars and many other things, the UN began to consider the creation of an international criminal tribunal for Sierra Leone, similar to, as I said previously, those of Rwanda and the former Yugoslavia. It also recommended that the court have subject matter jurisdiction for crimes against humanity, war crimes, serious violations, and international humanitarian law. It would, unlike the previous mentioned tribunals, it would not charge crimes against genocide. And finally, on January 16, in Freetown of 2002, the Special Court of Sierra Leone was established. So now Marga is going to talk about the crimes.
So in order to talk about the crimes, I thought it was important to highlight in the Civil War, the Revolutionary United Front, the RUF, which supported the National Patriotic Front of Liberia, because these were the two most, the groups that used the most brutality in the war. So now going on to the crimes. So the first crime it's important to talk about is the crimes against humanity. The majority of the crimes were perpetrated by the RUF. During this conflict, tens of thousands of civilians were killed and up to 1/4 of the population was displaced. The most notorious mass killings was on 1999 Freetown massacre by the RUF, when they decided to enter Freetown in a brutal assault, which was known as Operation No Little Thing, in which rebels entered neighborhoods to kill and indiscriminately. Over 7,000 people were killed, and that at least half of them were civilians. The brutality was such that some of the methods used included incinerating people alive while locked in their houses, hacking civilians' hands and other limbs off with machetes, and even eating them. In this case, the actus reus is done. This is the act of having killed the people, and the mens rea, it was wanted to do this in order to overthrow Joseph Momo government, and the specific mens rea was because it was based on the political party. The next crime it's important to talk about, it's slavery, specifically of minors. About 1/4 of the soldiers serving in the government armed forces during the Civil War were under the age of 18. Recruitment methods were brutal. It was common for children to be abducted. Sometimes they were forced to kill members of their own families so as to make them outcast. They were also drugged They were forced into conscription by threatening family members. In this case, the actor's role is done. This is the act of abducting and slavering the minors, and the mensha is the intention to take away their human rights in order to use them to kill for them. And this specific mensha, it's based on the political party. And then the last one is the crimes against sexual liberty. During the war, gender-specific violence was widespread. Rapes, sexual slavery, and forced marriages were the most common during this time. It was common for women to be abducted for use as a sex slave, or they could also be forced to be combatants, but this was less common. Women who were, for example, in the RUF, of which we talked about before because of its extreme brutality, were carved the initials RUF in their body in order to be identified as their own property. They were expected to provide sexual services to the men of the militia. A report from the PHR stated that the RUF was guilty of 93% of sexual assaults during the conflict. In this case, the actor's role is done because this is the act of abducting and violating the sexual freedom of the woman. The mensha is the intention to take away their sexual liberty, and the specific mensha, it was based on the sex and the political party.
Okay, so now moving on to the characteristics of the Special Court of Sierra Leone. We, as Isa mentioned before, it was kind of innovative or revolutionary for the moment, in the sense that it was not 100% international, as its previous two international, its predecessors, the Criminal Tribunal for Rwanda and Yugoslavia, which were 100% international. In this case, it was not solely imposed by the United Nations on the country, on the state, but it was an agreement. It was the fruit of a bilateral agreement between the government of Sierra Leone and the United Nations. And such a hybrid or mixed nature can be shown, or it's expressed in several aspects. For instance, its composition with a mixture of domestic international judges. Also, it was the first hybrid court with primacy over domestic courts, and its statute included not only the international humanitarian law as the previous statutes of Yugoslavia or Rwanda, but also there was reference to the domestic legislation of Sierra Leone. Regarding its jurisdiction, we can find the temporal, personal, and territorial. The temporal jurisdiction, there was kind of an issue regarding this temporal jurisdiction because the as is said, the court granted amnesty to the combatants. So the Security Council came to a medium agreement saying that the temporal jurisdiction will be from November 30, 1996, since it was the timing when the Abidjan peace agreement failed and escalation of crimes began. Therefore, the temporal jurisdiction will be since 1996 instead of 1991. Regarding personal jurisdiction, there was also kind of an issue with the naming or the wording of the statute that specifically labeled those who bear the greater responsibility instead of those who bear responsibility, as other statutes of the international United Nations international tribunals mentioned. Therefore, they were narrowing the scope, the personal scope of this court. And also, there was a human rights issue of the trying of minors, because a lot of combatants were minors. And that's why Article 7 was included, that foresee a special procedure for these minors from 15 years old to 19 years old. Lastly, the territorial jurisdiction, we find that also kind of innovative. It was going to be the locus, the situs, the place, was going to be in the place where the events took place, which is Sierra Leone. Therefore, this kind of also posed kind of difficulties for witness protection, but they were kind of overall overcome. Last, also, as its former two international courts, it is going to be divided into instances, the trials chamber and the appeals chamber. Now, procedure.
Okay, so now I'm going to be talking about the procedure and especially about the rules of procedure and evidence provided by the court. So we have a table, the rules of procedure provides us with a table of content, which is divided in two parts. Firstly, we have Part 1, which talks about the general provisions. Part 2, which talks about the cooperation with states and judicial assistance. Part 3, which focuses on the organization of the residual special court and has 6 parts regarding the judges, the presidency, internal functioning of the special court, the chambers, the register, and the prosecutor. And then we have part 4, which focuses on the investigations, the rights of suspect, accused, and convicted persons, which is divided in 2 sections, one regarding the investigation, another regarding the defense counsel. The second part is formed by the part 5, which focuses on the pretrial proceedings, is divided in 5 sections: the indictments, the orders and warrants, the production of evidence, the depositions, and the preliminary motions. Then we have part 6, which is the trial proceedings. We have the general section, well, we have 4 sections, which is the general provisions, the case presentation, the rules of evidence, and the sentencing of procedure. Then we have the 3 remaining parts, which are the appellate proceedings, the review proceedings, and lastly, the pardon, commutation of sentence, and early release. So now I am going to talk about the case presentation. So firstly, we have the opening statement. As we all know, each party has the right to make an opening statement in support of his or her case, and the president can limit the length of these statements in the interest of justice. Then we have the Rule 85, which is the presentation of evidence. So each party is entitled to call a witness and present evidence. Basically, we have the evidence for the prosecution, the evidence for the defense, and the president may also ask for some specific evidence. Then we have the examination in chief, cross-examination and re-examination that shall be allowed in each case and is made towards the witnesses. The accused may, if he desires, to appear as a witness in his own defense, and he should give all his evidence under oath or affirmation. Then the evidence may be given directly in court via communications such as media, including video, closed circuit televisions, and the method will be chosen by the president or the designated judge. Then we move to Rule 86, which is about the closing arguments. So after the presentation of all the evidence, the prosecutor shall and the defense may present a closing argument. A party shall file a final trial brief with the president, and it cannot be later than 5 days prior to the day of set of the presentation of that party's closing argument. But this can be altered by the president or the designated judge. Then we have that the parties shall inform the president or the designated judge of the anticipated length of their closing arguments, so that the president can limit the time length of those arguments in the best interest of justice, as I mentioned previously. Then we move to Rule 87, which is about the deliberations. So firstly, we have that after the presentation of closing arguments, the president or the designated judge shall declare the hearing closed, and they shall deliberate in private. And if they find guilty someone, they have to provide a statement that provides that this accused has been proved guilty beyond reasonable doubt. Then the trial chambers shall vote separately on each count contained in the indictment. And lastly, if the president or the designated judge finds the accused guilty on one or more accounts contained in the indictment, it shall also determine the penalty to be imposed in respect of each of these counts. Lastly, we have the Rule 88, which regards the judgment, and as we all know, the judgment shall be pronounced in public, and the judgment shall be accompanied by recent opinion in writing. So now moving forward, Bea will be talking about the motions and the legacy regarding the procedure.
So regarding motions, we can see that they are linked to a timing requirements because they shall be brought by the party within 21 days, which is very important. Also, regarding the moment, following the disclosure of the prosecution to the defense, all the material envisaged by Rule 66, which is all the witness statements that has to be disclosed from the prosecution to the defense. Moreover, regarding the moment, a motion shall be disclosed, shall be submitted in the pre-trial or post-trial moments, never in mid. So in order to enforce judgments or in pre-trials before commencing the trial. We have several types of motions. The most common ones can be objections based on lack of jurisdiction or on defects in the front of the indictment. We also find application for severance of crimes joined in one indictment under Rule 49 or for separate trials under Rule 82 of the Rules of Procedure of the Special Court. Then we have also objections based on the denial of request for assignment of counsel or objections based on abuse of process. So now moving on to the legacy of this special court. So we see that the goal, the ultimate goal or the mandate of this court was to try those bearing the greatest responsibility, which was very important, for serious violations of international humanitarian law and such provisions as a combination of Sierra Leone and domestic law since the temporal jurisdiction November 13, 1996. Due to all the events that were committed during the country's decade civil war. Okay, although there were a lot of improvements and there were a lot of, let's say, achievements made by these special courts, also there was room for improvement in several aspects. First, we can point out the low budgets. So this special court was financed through voluntary contributions instead of the regular budget that was installed by the UN for the previous tribunals. Therefore, there was a lot of unfinanced or let's say underfinanced aspects during the work of this court that that could be shown. For instance, in the inequality of arms between the defense and the prosecution, in the witness protection. So all these underfinanced had a lot of, let's say, repercussions and negative repercussions in the work of the court. Also, we have as said before, the narrow interpretation of those who bear the greater responsibility. So in the statute, we find that they named those who bear the greater responsibility for the personal jurisdiction instead of those who bear responsibility. And this left untried a lot of, let's say, perpetrators and a lot of participants who also had a high stake in the events and also were highly involved. For example, regional or mid-level commanders that were not taken into account but were highly involved also. We also have a cooperational issue in the case of the Taylor case.
Sorry to interrupt. Just as a reminder, we have 5 minutes left. Well, specifically 3 minutes left. So.
Okay, so yes, we say we have cooperational issues in the Taylor case to bring Taylor, witness protection because he was in their own country, and the juvenile prosecution and Article 7 that brought out of human rights issues. The outcome, we find that they were finally, as we can say, there were 23 indictments, but finally they were 7 people that were finally prosecuted. Remarks, these are all of the remarks and the legacy that left behind the courts and case studies. So very briefly, we find that in this case, which is prosecutor versus Brima, Camara, and Kanu. So basically, we find that they were found guilty of 6 counts, under 6 counts, as we can see here, of Article 3 and also Article 3 of the Geneva Convention and Protocols of Work, etc. And on appeal, we find that it's very interesting how the joint criminal enterprise liability was formulated and defined. And we see how the appeal chamber defined this joint criminal enterprise. And it says that ultimately, the joint criminal enterprise must not be only defined by its ultimate purpose, but also by the means that it was carried. And here we saw that although the ultimate purpose of the joint criminal enterprise, in which these 3 participants who were commanders and were authorities of the military groups, we see that also the purpose and the means also were criminal. Therefore, they were found to be participating and leading a joint criminal enterprise. Okay.
Okay, so now I'm going to talk about the Charles Taylor case. So Charles Taylor is the former president of Liberia, and from 1989 to 1997, Taylor led a rebel group called the National Patriotic Front of Liberia. He was tried and convicted for 11 charges arising from war crimes, crimes against humanity, and other serious violations of international humanitarian law, committed from November 30th, 1996 to January 18th, 2002 during the Sierra Leone Civil War. The 11 specific counts against Taylor were 5 counts on war crimes, terrorizing civilians, murder, outrages on personal dignity, cruel treatment, and looting, 5 counts on crimes against humanity, murder, rape, sexual slavery, mutilating, and beating, enslavement, and 1 count for serious violation of international humanitarian law, recruiting and using child soldiers. And finally, on May 30th, 2012, judges at the SCSL sentenced Taylor to a jail term of 50 years after he was convicted of aiding the commission of serious crimes in Sierra Leone and the planning of attacks on various towns in late 1998 and January 1999. So thank you for watching. We hope you enjoyed our presentation about the Special Court of Sierra Leone.
Bye.
Bye-bye.
Bye.
Bye. Okay.